Right now, there are employers across the country sitting on approved job offers, workers who packed their bags and made plans, and staffing agencies that built their entire summer season around a process that has just hit a wall. If you are a hospitality business waiting on kitchen staff, a landscaping company that needs crew before the spring rush, or a worker who was counting on that H-2B approval coming through, what happened this week at USCIS directly affects your livelihood. And if you are still filing or planning to file an H-2B petition right now, you need to stop and watch this entire video before you spend another dollar or submit another document. Welcome back to USA Immigration Path. While social media is full of noise and half-explained headlines, we are looking at the official text, the USCIS announcements, and the actual regulatory framework so you understand not just what happened, but what it means for you specifically. This channel exists to be your calm, reliable source in moments exactly like this one, when the news drops fast and the consequences are real. And before we go further, the standard but important note. I am an immigration policy analyst and educator. Everything in this video is research-based and designed to help you understand the system clearly. But this is educational content, not legal advice. Your situation is specific, and you should always work with a licensed immigration attorney before making filing decisions. With that said, let's get into exactly what is happening. USCIS has officially announced that the H-2B cap for the second half of fiscal year 2026 has been reached. That means the agency has received enough petitions to hit the numerical limit allocated for this period, and as of the announced cutoff date, USCIS will reject and return any new H-2B cap subject petitions that arrive. Not delay them, not hold them pending review, return them. That distinction matters enormously, and we are going to come back to it. To understand why this is such a significant moment, you need to understand how the H-2B cap works at a structural level. Congress set the statutory annual cap for H-2B visas at 66,000. That number is then divided into two equal halves. The first half, 33,000 slots, is reserved for workers whose period of need begins in the first half of the fiscal year, which runs from October through March. The second half, another 33,000 slots, covers workers whose period of need begins between April and September. This is the half that has now been exhausted. So when we talk about the cap being reached for the second half of FY2026, we are talking about all 33,000 of those available slots being claimed. Employers filed petitions, USCIS processed them, and the numerical ceiling has been hit. What is now a closed door was, just weeks ago, a window that many employers were still planning to climb through. But this is where it gets complicated, and this is the part that most people are glossing over in their coverage of this announcement. The H-2B program has never been a simple first-come, first-served filing race in the way some people imagine it. When USCIS announces that the cap is reached as of a specific date, they typically receive more petitions than available numbers right around that cutoff period. What happens then is that USCIS uses a lottery system for petitions received on or near the final receipt date. Petitions that are not selected in that lottery and petitions received after the cutoff date are rejected and returned with their filing fees. That means employers who sent packages in good faith, who paid attorneys to prepare petitions, who secured Department of Labor certifications, can find themselves getting everything mailed back with a rejection notice, no credit, no wait list, no appeal on the cap issue itself. This is a hard reality for a lot of businesses right now, and it is important to sit with that for a moment before jumping to solutions. Stay with me here, because the next part directly affects what options you actually have going forward, and there is more nuance in this situation than the headlines are showing. Let's look at the facts, not the fear. The H-2B cap being reached does not mean the program is shutting down. It does not mean workers who are already approved and in status are affected, and it does not mean that every employer who needed H-2B workers is completely out of options. What it means is that the standard cap subject pathway is closed for this half of the fiscal year. That is a significant obstacle, but it is a defined and navigable one if you understand what alternatives exist. The first thing employers need to understand is the concept of cap-exempt workers. Not every H-2B worker counts against the annual cap. Workers who have already been counted against the H-2B cap in one of the 3 most recent fiscal years and are returning to H-2B status are exempt from the cap. This is meaningful. If you employed H-2B workers in FY2024 or FY2025 who are returning to work for you again this season, your attorney may be able to file a petition for those specific returning workers without it being subject to the numerical limitation. This is not a loophole. It is a built-in provision in the regulations designed to give employers some continuity. But it requires careful documentation of prior H-2B status, so this is not something to attempt without experienced legal guidance. The second alternative that employers are watching closely right now is the Supplemental H-2B visa program. In recent years, the Department of Homeland Security has used its statutory authority to release additional H-2B numbers beyond the 66,000 cap, often in coordination with the Department of Labor. These supplemental allocations have ranged from tens of thousands of additional visas in some years, and they have typically been targeted at returning workers, workers from specific countries, and industries facing documented labor shortages. The critical word here is if. As of this video, a supplemental allocation for the remainder of FY2026 has not been officially confirmed. But historically, when the cap has been reached this early in the season with significant employer demand still unmet, DHS has often responded with supplemental numbers. Watching for that announcement is now the #1 priority for any employer who still needs workers this season. Let me ground all of this in something real because legal frameworks can feel abstract until you put a face on them. Think about a family-owned resort in coastal New England. They run their operation from Memorial Day through Labor Day, and they depend almost entirely on H-2B workers for their housekeeping, dining room, and front desk operations. The owners started the H-2B process in January, got their Department of Labor certification, worked with their attorney to prepare the USCIS petition, and were preparing to file right around the time the cap was hit. Their petition may now be returned. The workers they were counting on, some of whom have worked at this same resort for several seasons, cannot come. The owners are now looking at opening week with a staffing gap they cannot fill from the local labor market. They have already sold reservations. They already have guests booked. The ripple effect of that single USCIS announcement touches every part of their business. That is the real weight of what we are talking about. And for the workers themselves, many of whom come from countries where an H-2B season represents a year's worth of economic stability for their families, a rejected petition is not just a paperwork issue. It is a life plan that has to be rebuilt. Most employers and workers in this situation are not aware of one specific and time-sensitive step that could make a meaningful difference right now, and we are going to cover that in the action steps coming up in just a moment. Before we get there, let's clear up one more piece of misinformation that tends to circulate whenever the H-2B cap news breaks. Some people are claiming that workers currently in the United States on H-2B status are now at risk of losing their authorization because the cap has been reached. This is not accurate. If a worker is already inside the United States with an approved H-2B petition and a valid period of authorized stay, the cap announcement does not affect their current status. They are not suddenly out of status. Their employment authorization does not evaporate. The cap affects new petitions being filed now. It does not retroactively invalidate petitions that were already approved and processed before the cutoff. Spreading that kind of misinformation creates real panic in vulnerable communities, and it is exactly the kind of noise we exist to cut through. Now let's talk about what you should actually do. 3 clear steps, right now. The first step is to verify your petition status and receipt date immediately. If you or your employer filed an H-2B petition recently and have not received a receipt notice from USCIS, contact your attorney today. The question you need answered is simple but urgent. Was your petition received before or after the official cap cutoff date? If it was received before the cutoff, you may still be in the lottery pool. If it was received after, you need to know immediately so you can stop waiting and start planning your next move. Do not assume, confirm. The second step is to have your attorney assess whether any of your workers qualify for the Cap-Exempt returning worker provision. Pull your records from the last 3 fiscal years. Identify any worker who held H-2B status with your company in FY2024, FY2025, or FY2026 so far. These individuals may be petitionable right now without being subject to the cap. For businesses that have built relationships with returning seasonal workers over multiple years, this provision could be the bridge that gets you through this season. The third step is to set up a monitoring system for the supplemental H-2B announcement. This means following USCIS.gov directly, subscribing to DHS news releases, and making sure your immigration attorney is actively watching for any Federal Register notices related to Supplemental H-2B allocations. When that announcement comes, if it comes, the filing window tends to move quickly, and the numbers get claimed fast. Being ready to file on day one of a supplemental release is not optional. It is the difference between getting workers and not getting workers. The H-2B cap situation is a reminder of something that the immigrant community and the employers who rely on seasonal labor know deeply. This system rewards preparation, information, and speed, and it punishes people who are operating on outdated advice, missed deadlines, or incomplete information. That is exactly why being here, watching this, staying connected to a source that tracks these developments in real time, is not just a nice thing to do. It is a practical, strategic decision for your business and your future. Immigration policy moves fast. Fee changes, cap announcements, supplemental allocations, regulatory updates, any of these can change the landscape between the time you close this video and the time you open your laptop tomorrow morning. Subscribe to this channel and turn on notifications so you are never the last person to know. Share this video with the employers, workers, and advocates in your network who are navigating the H-2B process right now, because someone in your circle is probably making decisions based on information that is no longer accurate. We will be here when the next update drops. See you in the next one.